We are fortunate because, as we know, Adam is going to be covering the Comitatus, I can say Posse Comitatus Act trial. It's a bench trial that's going to launch in about 45 minutes, 12:30 Eastern, 9:30 Pacific, regarding Trump's use of military force and presence in California. If y'all recall, I know we've been covering a lot of stuff, as has Adam, but the best thing about Adam Klasfeld is not only what a great guy he is and how thorough he is, but he actually is in the courtroom physically when he can. In this instance, can't do it in the courtroom per se, but we'll be covering it and making sure that he's getting us up to speed. So I wanted to steal some time with my friend Adam, A, because we're friends, and B, because he and I have been incredibly invested, as all of you have been, on the Ghislaine Maxwell Epstein stuff. Look, Adam and I know there's this huge declaration of a federal presence in D.C. right now. It's serious. We'll talk about it at some other time. But I also think, Adam, maybe you agree, maybe you don't. It's a distraction. It's yet another distraction from the Epstein files. But folks, a 31-page order. Adam and I have had time to go through it. Adam, I use the adjective scathing. What adjective would you use about this order?
It absolutely blistering. He filleted the government's rationale here. I haven't seen a federal judge in a long time go out of the way to speculate as to the government's motives here. And I just want to read this one paragraph because my jaw hit the floor when I was watching.
Same. Go ahead.
The one colorable argument under the special circumstances doctrine for unsealing the case, in fact, is that doing so would expose as disingenuous the government's public explanations for moving to unseal the Ghislaine Maxwell grand jury records. A member of the public appreciating that the Maxwell grand jury materials do not contribute anything to public knowledge might conclude that the government's motion for unsealing was aimed not at transparency, but at diversion, aimed not at full disclosure, but at the illusion of such. And that just encapsulates for me, Katie, the entire ruling. And he goes in great detail as to why the government itself admitted that there's nothing new here, while claiming under the same breath that this is of great historical importance and will satisfy the curiosity of all the people clamoring for more information about the Epstein files, and why they chose this avenue of grand jury unsealing, one of the most difficult kinds of documents to unseal. And he said flat out, anyone who attended the Ghislaine Maxwell trial would find out that there's nothing new here. He quoted Gertrude Stein, the great poet, saying there's no there there.
There you go.
And I covered the entire Ghislaine Maxwell trial. That's what folks like you and me and every legal expert were saying from the get-go, that if you wanted to get real transparency in the Ghislaine Maxwell and Jeffrey Epstein matter, this isn't the way to do it.
I thought, first of all, I too went to, and folks, I will drop the link to the order in the body of the post that will be coming up from this conversation with Adam. But I too, Adam, went to page 20 of 31, and people, that's what Adam was just citing to, that paragraph. To use adjectives for a federal judge, to use adjectives like disingenuous, to use this and to use words like misleading, deceit, this idea that even the judge was calling out the Trump administration for its wrong reasons. It was trying to do the head fake that we have been talking about since day one on this motion to unseal. The other thing, Adam, I appreciated from this order that I wanted our viewers to know is this judge, this 31-page order, methodically walked through the procedural posture and the procedural history of this case, and also drilled down to explain to those of us in the American public that clearly didn't know what happened at these confidential secret grand juries, what was presented. It was one law enforcement officer, people. One law enforcement officer testified. There were a few exhibits that contained some PowerPoints, etc. But there was nothing there, and it's so important that a federal judge who we know, Adam, now the administration's going to blame. They're going to say
Right.
this federal judge refused to turn this over even though we wanted it. And, most people in MAGA land, Adam, are not going to try to read this 31-page order and will not listen to us explain that even the judge who got the entire unredacted grand jury transcripts as well as the exhibits said, as you just quoted, there's no there.
Right. And, as you were saying, Katie, it was very clear that the government's maneuver here is to set up federal judges as the fall guys. And he goes into it. And what I think was so effective in this ruling is that he quotes the government directly. Now, when I say the government, I keep saying the government. None of the prosecutors that prosecuted Ghislaine Maxwell had anything to do with, or likely had wanted to have anything to do with, this gambit. The government here is Pam Bondi, Todd Blanche, two of Trump's former attorneys, and Jay Clayton, who's a political appointee, the U.S. Attorney for the Southern District of New York. And I want to read one more paragraph because it just goes down the list about what these records do not contain. Says a member of the public familiar with the Maxwell trial record who reviewed the grand jury materials that the government proposes to unseal would thus learn next to nothing new. The materials do not identify any person other than Epstein and Maxwell as having had sexual contact with a minor. They do not discuss or identify any client of Epstein's or Maxwell's. They do not reveal any heretofore unknown means or method of Epstein and Maxwell's crimes. They do not reveal new venues where the crimes occurred. They do not reveal new sources of their wealth. They do not explore the circumstances of Epstein's death. They do not reveal the path of the government's investigation. So what they do not reveal is encyclopedic. Anything that the public has been clamoring for, these files don't reveal anything, and the government wants to is choosing and admitting that these records don't reveal anything new. But in the interest of transparency in the historical record, we must unleash the documents no one's asking about and that are the most difficult to release. It's a perfect recipe if you want to set up a straw man and a fall guy in the federal judiciary.
Yeah, and we're grateful to everybody tuning in right now. And Cecile Q, I saw your thing. I was just about to say one small correction what Adam said. I also don't believe that Bondi and Blanche are, quote, former lawyers for Donald Trump, which I think creates the conflict of interest which exists in terms of Blanche having those conversations with Ghislaine Maxwell, et cetera. I just want to underscore something on page 17 that Adam and I just talked about. And this is literally from the judge's order. He says each grand jury received evidence on a single day. So here we go as well. And what we appreciate, Adam and I, is the footnotes are always very important in not only in cases, but in orders. And if you look on page 17, and again, we'll drop this order in the substance of the post on Substack. Footnotes 14 and 15 on page 17 actually tell you not only the dates that the grand juries met for Maxwell, because there were 2 grand juries that met, but also the testimony and from whom. And on the first grand jury meeting on June 29th of 2020, it was just an FBI special agent. That testimony lasted 1 hour and 25 minutes, and there were only 2 exhibits that were presented. The second Maxwell grand jury met on March 29, 2021. That was testimony from a New York Police Department detective. His testimony only lasted 1 hour and 48 minutes because the rest of it was really the reading into the record of that special FBI agent's testimony from the first grand jury. So the reason why I'm sharing this with all of you is because of this. It was only one law enforcement agent. The Trump DOJ wants you to think, or wants, not you, because y'all are too smart for this, but wants the American public to think that there was a parade of witnesses, including victims, etc., that came through to this grand jury. But as Adam and I have explained, and Adam has a fantastic Substack where he breaks it all down as well, grand juries you're allowed to use hearsay, meaning you're allowed to have a witness come in and say, my name is Katie Phang. I'm an FBI special agent, and I spoke to Adam Klasfeld. Adam told me the following. Normally in an evidentiary proceeding, for example, or a trial, you're not allowed to have the hearsay of what Adam told Katie. But in this instance of a grand jury, this summary witness of this law enforcement agent can take the stand and do it. But what Judge Engelmary makes also clear is this. The assistant U.S. attorney puts the witness on the stand. For those of you that want to know the kind of nuts and bolts, because I used to present to grand juries, you put the witness on the stand and you ask that person questions. It's not just a narrative, the person running their mouth for 2 hours. You, as the prosecutor, want to present just enough to be able to get your indictment from those members of the grand jury. And so, Adam, when you read this order, how much do you appreciate as well the fact that the judge calls out the Trump DOJ for its failure to contact the most important people in this whole story?
Victims and other, well, there's another part, Katie, I also want to call attention to. He
Sure,
talks
sure.
about speaking about failures to call certain people. There's
Yeah.
an entire section where he addresses the disappointment of the victims in this decision, because when the Trump administration initiated this process, they began a process that involved hearing from all the parties, including the people that they forgot to notify. That's the victims. And he says, in a footnote that you mentioned one footnote, there's another footnote
Love the footnotes.
in
Yes.
page 29 about what has been distressing the victims in the
Hmm.
Maxwell matter. And it's not just the grand jury. They're worried about clemency. They're worried about the meeting between Todd Blanche, Trump's former criminal defense attorney, as though she were a credible authority. Maxwell. That's what they say in the footnote. And he says, there's nothing I can do about that. I'm just a judge presiding over the grand jury matter. And you know what? I think that maybe you wouldn't be so keen to unseal these grand jury records had the government been honest, had the government told you there's nothing new here. So that was a very striking part of the ruling, in my opinion. And it was also, I remember seeing Pam Bondi
Mm.
as in the impeachment of Donald Trump during the first impeachment. She was arguing his defense over in Washington, D.C. I was on Capitol Hill watching the whole thing. To your point, Katie, this conflict of interest of having the two people at the top of the DOJ, and this is just an ongoing trend where you never had seen. And we've been covering this for a long time. You're an attorney. When does the top of the Justice Department join a case, what amounts to here a public records case? This is highly, highly unusual, except it's now happening all the time during Trump's second term. Because one of the things that Pam Bondi started this administration by saying in a memo was that the DOJ are now, quote, the president's lawyers. And that, and
No,
this is a, this is
and
a
I'm glad that you
manifestation.
say this, Adam, because and for those of you that are just joining us, I just saw a gentleman. The name came by so fast, saying just joining now. Summary is this: the judge who had the motion to unseal the DOJ's motion to unseal the grand jury transcripts in the Ghislaine Maxwell case. And the reason why Adam and I are specifying that is there are 3 grand juries, 1 in Florida, 2 in New York. 2 had to do with Epstein, 1 had to do with Maxwell. The one in Florida has already said no to the unsealing. Now the one in the Maxwell case says no to the unsealing. We are waiting to hear from Judge Berman concerning the Epstein files. There may be a critical difference, Adam, in that. I don't think so. I think we're also going to see a denial as well, but I'm interested in seeing Judge Berman also hopefully issue another scathing, blistering order like this judge just did. But what you may have missed if you guys are tuning in right now is the reality, which is